If you're hurt on the job and become disabled, you need to know your rights. Christy Hafner recently sat down with attorney Jim Higgins to find out more about how a Tennessee lawsuit could affect you or a loved one. Jim, thank you so much for being with us today.
Thank you.
Now, we are talking about ADA and one specific case against a Tennessee newspaper. Talk to me about that.
Well, this was a case that recently happened where a person was pretty high up in management at a Tennessee newspaper, and he had a disability with his back, and he asked for a reasonable accommodation is what he thought was, and what seemed to be reasonable, and that was that he be able to use a restroom, which was a small women's restroom near his office. And he did that for a week, and then after a week he was terminated. So it resulted in a lawsuit, and it resulted in a settlement for him for $150,000 for his back pay and front pay and all the income that he lost out on.
So what does that mean for other people?
Sure. Well, you know, I think it's just one of these cases that is a perfect example of what the Americans with Disabilities Act is supposed to do. And that is to protect people if they have a disability that can be accommodated, to encourage an employer to offer a reasonable accommodation. You know, they didn't have to put in a new elevator or install a restroom for him or anything. All they had to do was let him use this one place. He was not asking a lot. But for some reason, and I don't know why, and we see a lot of it in our office, is sometimes employers are just not willing to change their ways or to make a simple change in their system so someone can continue to earn a living even though they may have a disability.
So what should someone do if they have a claim?
Well, you know, what we always tell our clients is put your complaint in an email, in a fax. You want to document it. Sometimes we get in these cases and a client may say, hey, I asked my employer to simply, you know, let me sit for a few hours because I have this back problem, or, you know, I need to bring my cane in, or whatever it is, and the employer will say, well, you never asked that. So it's important to document, and it's so easy nowadays with email and text and all that. So you send your employer an email and say, I'm having some problems, here's my disability, can you help me with this? And then there is no question about it. Then if you are getting pushback from that, if you aren't getting that accommodation and you're just not sure what to do, you're welcome to call our office. I mean, I talk to people a lot of times, and a lot of times they don't ever need to hire us, but we can let them know where they stand, what their rights are, and a lot of times when they're just kind of armed with that information, it can help them smooth things out at work.
So if you do email someone and you get it in writing, at what point should you contact an attorney if nothing is being done?
Well, if you get, a lot of times, most of our cases come in when people get terminated. I mean, that is truly, obviously, it's a you know, no-brainer kind of answer, but that's what happens. And a lot of the times we handle, like we have a big workers' comp section, and if we have a client who has a permanent disability and they are not rehired, they're not returned to work, we always have our employment law section look at it to determine if there's an ADA violation. But truly, when there's been this adverse action, your pay's cut, you lose your job, then I would suggest you contact our office and discuss it.
And I would imagine some people are afraid to let their employer know that this is going on. Is that pretty common?
It's very common and nowadays in this economy, and that's just a choice you've got to make.
All right, thank you, Jim.
Thanks.
The Higgins Firm is serving Tennessee. Give them a call at 615-353-0930, or for more information and a link to their website, just go to betternashville.com. We'll be right back.